Done? Hello aspirants. So today we are going to discuss polity previous year questions paper. So we'll start with 2025 paper and we'll try to also see 2024 previous year paper. As I have always emphasized that going through the previous year really helps. It will make you prepare that exactly what is the nature of question that UPSC is being asking, what is the nature of difficulty label, how is the composition in terms of difficulty label, and how you need to approach. So let's get started. So today, in today's class, we'll try to cover 2025 and 24 both. So let's see. Okay. So look at this question. Consider the following statement. Panchayats at the intermediate level exist in all states. To be eligible to be a member of panchayat at the intermediate level, a person should attain the age of 30 years. Panchayat at the intermediate level exist in all the states. To be eligible, the members of panchayat should be panchayat at the intermediate level, a person should attain the age of 30 years. The chief minister of a state constitutes a commission to review the financial position of panchayats at the intermediate level and to make recommendations regarding the distribution of the net proceeds of the taxes and duties leviable by the state between state and panchayats. So what could be the answer for this? I think this is simple. That's the questions belong to local self-government, and I believe the question is simple, direct and straightforward. But yes, you must study it very, very carefully. So first question, the panchayat at the intermediate level exists in all states. That is wrong. We have already studied that there has to be a certain populations. For that only that intermediate level is mandatory. Otherwise, there can be just 2 tier, right? Second, to be eligible a member of panchayat at the intermediate level, a person should attain the age of 30 years. Such thing is not mentioned in the constitution, whether intermediate or at the first level. What they have said, they should not be less than 25 years, right? So what does it means? Means they can be 21 years, not 25, 21 years. Anybody less than 21 years, that is what they have said. So it is not 30 years. It is not 30 years. So this statement is also wrong. The third one, the chief minister of a state constitutes a commission to review the financial. So it is not the chief minister, it is the governor, right? So all the statement is wrong. So answer is your D, right? So let's move to the second question. Consider the following statements about Lokpal. The power of the Lokpal applies to public servants of India, but not to the Indian public servant posted outside India. Second statement, the chairperson or a member shall not be a member of parliament or a member of legislature of any state or union territories. Only Chief Justice of India, whether incumbent or retired, has to be chairperson. The chairperson or a member shall not be a person less than 45 years of age on the date of assuming the office of the chairperson. Lokpal, the fourth statement, cannot inquire into allegation of corruption against the sitting Prime Minister. So say this question based on your bills and act. So for that you need to be updated. You need to know about the Lokpal Act, right? So this is not a very traditional question, but it is more, you can say, fusion of dynamic aspect in polity question. So the first statement, you must be knowing about the Lokpal Act. Lokpal Act 2013, right? So the first statement, the power of Lokpal applies to public servant of India, but not public servant outside India. That's not there. That statement is wrong. Public servants means public servant, they should be included. The second one, the chairperson or member shall not be a member of parliament. That part is correct. Yes, they should not be the member of parliament. But this part of the statement that only Chief Justice of India, whether incumbent or retired, shall be its chairperson. This part of the statement is wrong. So this second statement is also wrong. The chairperson or a member shall not be a person less than 45 years of age. So this statement is correct. This statement is correct. Yes, that is mandatory that they should be 45 years of age. That has been mentioned. Again, dealing with such kind of question, you should be knowing about the appropriate bills, policies and act of the Government of India. The next statement, Lokpal cannot inquire into the allegation of corruption against the sitting Prime Minister of India. This statement is also wrong. It can inquire. That is why the Lokpal has been made very, very strong, right? So what is the answer? The answer is your 3 only. Answer is A. I hope it is making sense. The discussion is making sense to all of you. Look at the next question. Sridhar? Question number 3. Yes, okay, fine. Do like this. No problem. Alright, so question number 3. Consider the following statement with regard to pardoning power of the President of India. Pardoning power of the President of India. I think this is simple question. Anyway, let's see. So, the exercise of this power by the President can be subjected to limited judicial review. Limited judicial review. Second, limited judicial review. The second one, the second statement, the President can exercise this power without the advice of central government. So, the first statement is saying that the exercise of this power by the President of India can be subjected to limited judicial review. Earlier, pardoning power of the President was not under the scope of judicial review, but with the Supreme Court saying that there cannot be anything which is outside the power of judicial review, because it is the judiciary who is the custodian of the constitution and rights of the citizens. So, the judiciary should have the right to judicial review. So, the first statement it is saying subject to limited judicial. So, do not get confused about the limited judicial review, they have the judicial review. So, the first statement is correct. The next statement, the President can exercise this power without the advice of central government. I think this pretty easy to understand that this statement is wrong or incorrect, because the President act always on the advice of Council of Minister, right? So, what is the answer for this? A, only one statement. I hope you are getting the clarity, yes? Move on to the next question. Consider the following pairs. Provisions in the Constitution of India and stated under. Separation of judiciary from the executive in public services of the state. Directive principle of state policy. The second one is valuing and preserving the rich heritage of our composite culture, and prohibition of employment of children below the age of 14 years in factories. So, again this question also I will put it in the easy category. This is easy, the question is very easy. I will put it under the easy category. So, the first you see separation of judiciary, yes it is separation of judiciary from the executive, article 50, right, the DPSP, that is correct. Second one, valuing and preserving the rich heritage of our composite culture, that is fundamental duties, yes it is there. Prohibition of employment of children below the age of 14 years, yes, article 24, so it is also there, fundamental rights. So, all of these are correctly matched. Again this question very easy question, you should not miss out this question. So, answer is your C, answer is your C, all the three are correctly matched, right. Moving on to the next question. Consider the following statements. On the dissolution of the House of People, the Speaker shall not vacate his/her office until immediately before the first meeting of the House of People after dissolution. Yes, the statement seems to be correct. Yes, it is correct, right? On the dissolution of the House of the People, the Speaker shall not vacate his/her office until immediately before the first meeting of the House. No, the statement is wrong, because on the dissolution of the House, the Speaker shall not vacate his/her office until immediately before the first meeting of the house, immediately before the first, they are saying immediately before the first meeting. So it is not like that. Till the new speaker is being appointed, he has to be there, right? And the first meeting in the first meeting of the house, the pro tem speaker is being appointed, right? The second statement, according to the provision of the Constitution of India, a member of the House of the People on being elected as the speaker shall resign from her political party immediately. Again, this provision is not there in India, though there has been a lot of discussion that such thing is prevalent in United Kingdom, and to make the office of the speaker more neutral, even very recently, or in fact it is ongoing, that the opposition now they are demanding the removal of the incumbent speaker because of an act of, or you can say the speaker seems to be working in a partisan manner. So there has been the demand from the opposition that the speaker should be removed, right? So they are going to pass a resolutions regarding removal of the speaker. Why? Because the speaker is behaving in a partisan manner, and this provisions we have been demanding, but so far it's not there. It is prevalent in UK. So this statement is incorrect. The Speaker of the House of People may be removed from her office by a resolution of the House of the People passed by a majority of all the then members of House, provided that no resolution shall be moved unless at least 14 days notice has been given. So yes, 14 days notice has to be given to the Speaker. So your answer is yes. Which statement? So here you can use the technique of elimination. This statement is wrong. Second statement is wrong. Second statement is wrong. Right. Second statement is wrong. So let's see where second is there, that will be eliminated. That the answer, this here, this is eliminated, and this is also eliminated because second. So as I told you, sometime the UPSC itself helps you by giving such kind of options, which is more easy for you to mark it in a correct manner. So you know, the second statement is very even in the first statement, suppose you are a bit confused that about the wording and all, you are little bit confused, but second, you know very clearly that such practices are not there in India, so you can eliminate. So what is the answer? 1 and 3 only. First statement, because first statement, why it is correct? Because till the first meeting of the parliament in the new session, after election the speaker will be there, but immediately he will resign, or you know, he will vacate the office, he or she will vacate the office, and that day one pro tem speaker will be appointed. And what is the work of the pro tem speaker? To see that to administer the oath of office to all the members of parliament, and secondly to see that election of the new speaker, right? So that's why that statement is correct. So 1 and 3 is correct, 2 is blatantly wrong. So again I'll put it to this question also in a easy category. This question is easy. So that's why I've been always telling you, polity is the one area where you can really score very high, but little mistake on your part in reading or understanding of the question or statement, you will end up marking wrong option. So be very careful. See, and many a time the technique of elimination works, many times, most of the time it works, and it will deburden you, it will help you in identifying the correct options. Yeah, so look at the next question. If any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Union Ministers shall be final. It is about the, if any question arises as to whether the member of the House of People subject to disqualification under 10th schedule, they are saying 10th schedule, right? And they have mentioned here president. So whether the statement is correct or not. The second, let's look at the second statement. There is no mention of the word political party in the Constitution of India. So the second statement is little bit, dicey. If any question arises as to whether a member of House of the People has become a subject to disqualification, this statement is incorrect. This statement is incorrect because why? It is the speaker. It is the speaker related to 10th schedule. You know that it is the speaker decisions and not the president's decisions, right? Particularly for the related with 10th schedule. So this statement is wrong. There is no mention of the word political party in the Constitution of India. Now this statement, why it is wrong? Because the 10th schedule have included it, right? The 10th schedule and 52nd Amendment Act has brought, because it is about basically the disqualification of the members of any political party if they are switching over the party or whatever it is mentioned in the 10th schedule, right? And in there the political party is mentioned. So that's why the answer is neither 1 nor 2. So be careful. I think this one here you have to be careful that it is not the president, it is the speaker. Now political party earlier it was not mentioned, but later on with the 10th schedule coming into being in the constitution, yes, the political party is mentioned, right? So both the statement are incorrect. Look at the next question. Consider the following statements. Statement 1. In India, the state governments have no power for making rules for grant of concession in respect of extraction of. In India, the state government has no power for making rules for the grant of concession in respect of extractions of minor minerals, even though such minerals located in their territories. Second one is, in India, the central government has the power to notify minor minerals under the relevant law. So this question is again, you can say, not directly from the polity, I mean constitution you can say, but yet somewhere related. So in India, the state government has no power for making rules for the grant of concession in respect. So you see, mines and minerals, basically the mines and minerals that comes under the purview of central government, right? They come under the purview of central government in respect of extractions of the minor minerals. So this statement is correct, right? 1 minute. Yes, not wholly, this statement is not wholly correct, so it is incorrect. In India, the central government has power to notify the minor minerals under the relevant law. See, it is saying in India, the central government has the power to notify the minor mineral. So you see, this kind of question, I can say little not that easy. This is not that easy. This kind of statement is not that, this kind of question is not that easy to handle, because it is not just by reading Lakshmikant polity or just knowing about the polity you will be able to handle. You should know about the mines and minerals are under the purview or under the control of which government. So the first statement is incorrect. Why? Because even the state government have some rights, right? It is both the state government and the central government can together, they should look into the minor minerals. They have particularly mentioned about the minor minerals. Secondly, in India, the central government has the power to notify. Of course, again, it is the finally the central government does it. If the state government also does it, it will be reviewed by the central government, right? So this statement is correct. This statement is correct. This is wrong. So the answer is both 1 and 2 are correct, but statement 2 explains the statement 1. Both statement 1 and 2 are correct, and statement 2 does not explain statement 1. Statement 1 is correct, but statement 2 is not correct. Statement 1 is not correct, but statement 2 is correct. So answer is your D. Answer is your D. Because we have seen the statement 1 is not correct and statement 2 is correct. So answer is your D. So as I mentioned you, this type of questions is little bit tricky, but please you can use your sense and still you can attempt this kind of question also. Now look at this question, question number 8. Which of the following statement with regard to recommendation of 15th Finance Commission of India are correct? So you see, it has recommended a grant of rupees 4,800 crores for the year this to this for incentivizing state to enhance educational outcomes. 45% of the net proceeds of union taxes are to be shared with the states. 45% they are asking. The third one, 45,000 crores are to be kept as performance based incentive for all the states for carrying out agricultural reforms. The fourth, it introduces tax effort criteria to reward physical performance. Select the correct answer. So you know, again this kind of question is also not that very easy. But it is not that difficult also. Why it is not difficult, I will tell you, because see this, they have given a lot of data here. So generally you can take a chance in this kind of question, you can take a chance, though while reading for the first time you feel that this question is really tough, right? But you can still take a chance, I tell you why. So first statement is related with some data, you know, some figure, we don't know, but still you can, most of the time, this is a trick, basically this is a trick. Most of the time I am saying you again with a caution, most of the time such statement are correct. This statement is correct. You don't know how much crores and how many crores has been given, but still you can assume that it's correct. The second one is saying 45% of the net proceeds. So this information we must know, it is not 45%, it is 41%. It is 41%, right? All of you must know. It is 41. Even the 16th Finance Commission, they have written 41%, right? So this statement is wrong. I think this is pretty easy to remember, it isn't, because if you read about Finance Commission, you will know that it is 41%. They have given the net proceeds to be shared with the state. So this statement is what it is showing, 45%, and this is incorrect. This statement is incorrect. The next statement again is saying about 45,000 crores are to be kept as a performance base. Again you don't know whether it is 45,000 or 50,000 or 50,000, but still, as I told you, still you can take a chance and you can mark, right? The fourth one, it reintroduces tax effort criteria to reward fiscal performance. Again, you know, this kind of statement where you are not very much sure, but at least you can know that yes, there has been a kind of a talk in the finance commission that they would reward and they would incentivize those states who are performing well in terms of their fiscal prudence or fiscal discipline. So even if I don't know thoroughly, I have been discussing earlier also, still these are the questions which can be attempted. This can be attempted. That is what the beauty of polity questions. Even if they look like difficult, still they are attemptable. So this is, so we know that the second statement is wrong. Second statement is wrong. So you eliminate wherever the second statement is there. First of all, you eliminate. You know that, right? This is what the technique of elimination, and this is really very useful, I would say. So this is ruled out, this is ruled out, and this is also ruled out. So even if I don't know all the statement, I just know that second is wrong, I end up marking correct. So this is what the UPSC is helping you out. UPSC itself is helping you out by just using the technique of elimination. You marked it correct. Just you knew one statement that yes, this statement is incorrect. I think that's pretty simple. All of you should know that statement was incorrect. It is 41%, not 45%. So again, I'll put it very easy category. This question, it's easy on the face of it. When you read it for the first time, it looks like tough, but when you see the option and read it thoroughly, it becomes easy. A question which seems to be difficult is actually very easy. And the option itself and the technique of eliminations is very useful, and it really helps, right? I've shown you live that how by the using of technique of elimination you can attempt a question and you can still mark it correct. Even if you don't know all these figures, you don't know what is the figure, still you end up marking correct option, right? The next question you see, with the reference of Indian polity, consider the following statement. An ordinance can amend any central act. An ordinance can abridge a fundamental right. An ordinance can come into effect from a back date. So you should have a good knowledge about the ordinance, isn't it? Article 120, 123 and 213. President and governor, they have power to make ordinance. So ordinance can amend any central act. Yes, it is true. See, there are certain acts which cannot be amended or cannot be, particularly the constitutional amendment. Constitutional, if it is a constitutional amendment act, again sometime the statement is framed in such a manner, it is little vague. If it is constitutional amendment act, then such amendment that cannot be amended by ordinance, that cannot be amended. So ordinance has the same power as that of the parliament has in making laws, right? But yes, they cannot amend the constitution, they cannot amend the constitution. But yes, central act can they can amend, yes, they can amend. And ordinance can bridge the fundamental right. So this statement is wrong. They cannot abridge a fundamental right through the ordinance. It required Constitutional Amendment Act, and it cannot be done by ordinance. An ordinance can come into effect from backdate. All of you know it has got retrospective effect. Retrospective. An ordinance has got retrospective effect. It can come into effect from the back date. So the statement is 1 and 3. 1 and 3. The statement 1 and 3 is correct. I hope you are getting, you may little bit get confused here, but there is no option. Even if you think that, as I told you, sometimes the sentences are framed in little vague manner, but when you look at the option, it will help you. The options itself will help you. You know this, say again, you know, here also technique of elimination you can use. You know that this statement is outrightly wrong, so 2 is eliminated, 2 is eliminated, 2 is eliminated. What is the options? 1 and 3. Even here you can use the technique of elimination. See, again, this is a interesting one. State and description. Arunachal Pradesh. The capital is named after a fort and the state has 2 national parks. Arunachal Pradesh, you know, Itanagar. Nagaland, the state came into existence on the basis of Constitutional Amendment Act. And Tripura, initially it was a part of C state and it was a territory, right, union territory, that then it became centrally administered territory in 1956 and later attained full statehood. So yes, so now you look at the options. So sometimes, you know, this kind of question can be a little confusing, but still look at the options and then again you can go through. How many of the above pairs are correctly matched? Only 1, only 2, all the 3, none. So you see here the capital named after a fort and the state has 2 national parks. Now you are not knowing exactly how many national parks are there, but named after fort, Arunachal Pradesh, Itanagar. So you can little bit, you know, sometime maybe even if you don't know thoroughly, still you can make some relation. You can make intelligent guess. So this statement is correct. The state came into existence on the basis of Constitutional Amendment Act. Yes. Initially it was a part C state, but it became centrally administered territory in 1956 and later attained full statehood. About Tripura, I think you must be knowing. So this statement is correct. So your answer is all the 3. So that is what, like, by using our sometime, you know, common sense and little analyze, if you analyze it well, many a time you will be able to solve more number of questions. Look at this, another question. With the reference to India consider the following bodies: Interstate Council, National Security Council, Zonal Council. It is talking about provision of the Constitution. Provision of the Constitution. So I think again this question is easy. I guess it's very easy. See, Interstate Council, yes, Article 263, you know, as per Article 263. National Security Council, no, you don't know that it is there any, as it mentioned under any constitutions or not. Zonal Council, again, it is a statutory bodies, right, created by an act of parliament, not by the constitution. So it is easy, I would say, the question is easy. Only 1. Consider the following statements regarding constitutional provisions in India. The Constitution of India explicitly mentions situations where governor of a state can act in his/her discretion. The Constitution of India explicitly mentions, they are saying explicitly mentions situations where the governor, so it is not like that, right? We have not, there is nothing mentioned in the Constitution like that. The second question, the President of India can on his/her own reserve a bill passed by a state legislature for consideration even without being forwarded by the governor of the concerned state. So this is little bit dicey, this topic. You will have little bit of confusion that whether the president can himself do. So generally whatever the president does, who is the representative of center in the state? It is the governor through the, see, otherwise also it is mentioned, like even 356 can be imposed on the report of the governor or otherwise, but bill, because any bill will first come to the governor, right? It will come to the governor, then only governor under article 200, 201, he can specially reserve the bill for the president if he feel that this bill is, it requires the consideration of president, then he can reserve the bill, right? So the explicitly the statement is wrong, right? The statement is wrong. And the President of India can on his/her own reserve a bill passed by a state legislature for consideration the President of India can either reserve a bill by a state legislature for consideration even without being forwarded by the governor of the concerned state. Now this is little dicey, this question is little dicey. So as per see with this question, see article 163 talks about that where he can use his discretion. Article 163 they have mentioned in the clause that, in the subclause, that the governor can explicitly mention situations where the governor of a state in his discretion. So they have mentioned, but exactly what is the situation, it cannot be mentioned, right? It cannot, though they have mentioned that under subclause of 163 that he has got the discretionary power, that is there. But what would be the situation, nobody can tell, right? It is very, very dynamic. There are certain situations, it has been mentioned, certain is left to the governor, right? So explicitly mentions situation where the governor can act in his discretion. Now this statement is vague. The statement is vague. The statement itself is vague. They have mentioned, but not all the situation can be again mentioned. So this statement is wrong. But then for some it can be correct also. So this kind of, I think it's a bit dicey. For I would go for neither 1 nor 2, but then this question one can dispute, it can be disputed, but I would go for neither 1 nor 2. President of India can his/her own reserve a bill passed by the state legislature for consideration even without being forwarded by the governor of the concerned state. Well, that is what we have not studied in the constitution that way, right? But it is not mandatory also, so it is very bit open ended kind of. I would go for this question, I would go for neither 1 nor 2, but yes, people can dispute it. Yeah. So that question is little vague. Consider the following statement regarding schedule areas under the 5th schedule of Indian Constitution. If an area in a state is declared as a schedule area under 5th schedule, the state government loses its executive power and a local body assumes total administration of such area. So it is not the total, you can say, If an area in a state is declared as a schedule area under the 5th schedule, the state government loses its executive power. So, of course, the government will lose, the state government will lose the executive power, and it will come under the governor, right? Governor with the schedule areas, the local body will be given the administrative power, the local body will be given, and in case if any changes has to be brought, the governor can intervene, but not the state government. The governor can intervene, but not the state government. So yes, this statement is correct. Second one, the union government can take over total administration of such areas under certain circumstances on the recommendations of the governor. So I hope so if it is 5th schedule, the state government loses its executive power. So you can say that they do not lose entire power, but whatever the executive power, whatever the state has the executive power, it will be in consultation with the local bodies, because it is saying local bodies use total administration of such areas. So yes, the local body has been given lot of area, you can say the power, but it's not like the state because here the executive also comes the governor, right? So little bit we have to think in such kind of question. It is not only the chief minister, it is also the governor. So the governor has the, isn't it? The governor has it, the power. So you cannot say the state government loses its executive power, because under the state government even the governor is a part of the executive, right? So this statement is wrong. Union government can take over the total administration of such area under certain circumstances on the recommendations of the governor. So generally, see, it is not mentioned like that. It is basically the governor. The governor has been given a lot of power regarding 5th and 6th schedule. Even the parliamentary law, cannot be applicable there. It has to be, even the governor will see that what parliamentary law will be applicable. So in that case, even this statement is wrong. Total administration of such area under certain circumstances on the recommended of the governor. No, it is not like that, because even the parliamentary law can be implemented there only with the recommendations of the governor. With reference to India, consider the following pairs. This kind of questions, again, National Automotive Board, the COIR Board, and National Center for Trade Information. So National Automotive Board, Ministry of Commerce and Industry. National Automotive Board, Ministry of Commerce and Industry. COIR Board, Ministry of Heavy Industries. National Center for Trade Information, Ministry of Micro, Small and Medium Enterprise. Again, this kind of questions, as I told you, for this I have many a time told that it is not easy, this kind of question, because you should know the information. National Automotive Board, which it is under which ministry? Automotive does not look like Commerce and Industry, Automotive Board. COIR Industries also does not. If you little bit think also, I think you will be able to, suppose I don't know. So, but automotive and commerce and industry doesn't look like matching. It can be under the transportation, right? Transport minister and all. COIR Board, again, Ministry of Heavy Industry, doesn't look like matching, is it? It doesn't look like matching. So suppose even if you don't know, if you read it very carefully, as I told you in the first time, the question looks bit tough, but if little you see and analyze, I think you will be able to answer. National Center for Trade and Information, again Ministry of Micro, it doesn't look like, because Center of Trade and Information, how can it be in the MSME only? How can it be in the MSME only? Because that deals with the National Center for Trade and Information, not necessarily related to MSME. It can be for the large scale industries also, isn't it? So all the three seems to be incorrect. So you can go with none. None. So I have shown you some of the questions. On the face of it looks very difficult to handle, but still if you analyze a bit and try to relate that whether it could be in this ministry or not, still you will be able to answer. So answer is D. Next question, consider the following subjects under the Constitution of India. This kind of questions many a time they had asked UPSC. List 1, union list in the 7th schedule. Second is extent of executive power of a state. Conditions of the governor office. For a constitutional amendment with respect to which of the above, ratification by legislature of not less than one half of the state is required for the bill. So what does, see, you should, I think all it should be there. Constitutional Amendment Office. Yes, this part, list 1, union list, of course, it has got federal issues. It is a federal. So wherever there are federal issues, wherever there are federal issues, ratification by the state is required. Ratification by the state is required, right? Extent of executive power of a state, it also deals with the federal provisions. It also deals with the federal provision, because you know the amendment making power is with the center or the union. So union cannot unilaterally disturb the executive power of a state, like whether the chief minister should have what and what power, or a governor. So they cannot do it. This is the federal, because it is relates with the federal. Union cannot by its own power cannot disturb the extent of power of the state. Okay, executive power of the state also, if there is any kind of changes, yes. But the third one, you see, conditions of the governor office, they can do it or not, because governor, the appointment condition, again you should know what is governor and how he is being appointed. So regarding his appointment, termination, salary, all this that deals with the condition of office of the governor. So that the union can do it unilaterally. For that the state consent is not required. For such amendment, state consent is not required. So yes, yes. So answer should be A, 1 and 2 only. I hope you are getting the clarity. At easy question, looks little tricky, but it is easy question. So let's do the last question of 2025. With the reference to the Indian polity, consider the following statement: the governor is not answerable to any court for the exercise and performance of his powers and duty of his office. No criminal proceeding shall be instituted or continued against the governor during the term of his office. It's criminal proceedings. Members of the state legislature are not liable to any proceedings in any court in the respect of anything said or vote given in the legislature or its committee. Members of the state legislature are not liable to any proceedings in any court in respect of anything said or any vote in the legislature or its country. Yes. So all the statement is correct, isn't it? Governor is not answerable. Article 3, these power deals with Article 361 of the Indian Constitution, isn't it? That's immunity is given to the governor, right? So both the statement is correct. The member of state legislature is not liable to any proceedings. This also related to the privileges and immunities. Privileges and immunities given to the member of parliament as well as state legislature. So I think this question is pretty simple. You should be able to solve. So all the statement is correct. All the statement is correct. I hope you got to know why all the statement is correct. The first two statement deals with Article 361, immunities given to the governor, and the third statement deals with the immunities and privileges given to the member of parliament as well as member of state legislature. So all the statement is correct, right? So answer is D. So with this we'll wind up today, and in the next class we'll continue with the more discussion on previous year question paper on various subject, so that you will be able to understand that though some of the questions at the initial look it looks little tricky or difficult, but if we analyze we can solve those questions. If you read it again twice and thrice, you will feel that no, these questions are attemptable and I should take the attempt. 99% that I will be correct, right? So please take a chance in those kind of questions where you feel that yes, these are the questions where I can take attempt. 99% it will be correct. And yes, some of the questions we have also seen in today's discussion, that how some statement can be vaguely framed. So yes, those kind of statements are a bit difficult to handle, but please look at the option, and by using the technique of elimination, even such question you can handle. All the best. We'll meet it in the next session where we'll be discussing more PYQs on the various subject. Thank you. All the very best.